Good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our bi-weekly, every other Thursday, community conference call. The answers are given subject to the disclaimers you heard when you were logging in. Let me get started with the frequently asked questions. Today is March 17th, 2022. I will, as I always do, first address those questions which I think have been asked frequently by the community. So they are marked as a set of frequently asked questions. I will ask for any follow-up questions. No new questions at that point of time, just any follow-up questions on what I have talked about. First one is, this is coming up actually quite frequently. Can I go from F1 or even J1 OPT directly to apply for my green card? And the answer is a qualified yes if you were not born in a country which has a huge visa backlog. So for instance, if you are born in India, you have many years of wait and it is very difficult to file a green card because it doesn't give you any right to continue to work. If you were born in a country that's not backlogged, there is a likelihood that within the life of your OPT and STEM OPT extension, you'll be able to get your green card. So the first thing that we need to worry about is which country were you born in? And if you are married, we also need to look at which country was your spouse born in. Because under the rules of cross-chargeability, you can actually inherit your spouse's country of birth. So let's say that you were born in India, but your spouse was born in, let's say, Kuwait. You could actually be charged to Kuwait. Okay, so that's the second thing we look at. I have also written an article on this on my author page in the Economic Times. So if you do a search on Economic Times space Rajiv, that's spelled with R-A-J-I-V, S dot, that's my middle initial, Rajiv S. Khanna, K-H-A-N-N-A or Khanna, you'll be able to come to that page and I have discussed this issue in a little bit greater detail. One thing I worry about is that because green card is not commensurate with the intention to stay temporarily in the United States, which is what the student visa requires, you can have difficulty when you travel or try to go get another F1 visa during the time that your green card is going on. So as long as you don't have those conditions hovering over your F1, you could potentially get your green card directly while still on OPT. So to go back to the question, Rahul says, I was born in the United Arab Emirates. That means he won't be chargeable to India. So because if you're not chargeable to India, it doesn't matter. You can be a citizen of India. But if you were born in UAE, then you'll be charged to UAE. I was wondering, with the ongoing corona crisis, would it be realistic to apply for green card within 6 months of job and get it before my 3 years of OPT ends? It's likely, highly likely. But even if you don't remember, the race is to file the 485 and to get employment authorization. That could be entirely plausible within 2.5 years. Okay. Does it interfere with the green card process? So if you're in the first year of OPT, I would need to look at the forms. I don't remember off the top of my head. I would have to look at the forms and decide whether and when it is safe for you to apply for a green card. So have your lawyers look at that carefully. It's certainly possible. Okay. So if the forms do not ask you about has anybody ever filed a green card for you, you are fine. Remember, the question asked on the forms is in this format. Have you or has anyone ever applied for an immigrant visa for you? Immigrant visa application is the I-140. So if you're going through PERM, even if somebody has applied for your PERM, it doesn't count as a green card application. So really the point where you need to worry is what happens once my I-140 is filed. And I think all of this can be managed with a little bit of careful planning. So potentially it is possible for you to go directly to green card from F1 if you are not chargeable to India. Does it help if I've been living in USA for almost 5 years? No. You might qualify for diversity lottery as well. I don't know anything about diversity lottery, but yes, you can apply for both. Are there any consequences for not filing form 8843? I don't know what that form is. I have no idea what that form is. Sorry, never heard of it. Star 5 if you have a follow-up question. Press star 5 on your phone if you have a follow-up question. No new questions, please. There being none, let's go on to the next frequently asked question. So this is an interesting question with many issues that do come up quite frequently. I am on STEM OPT. What all can I do? Can I volunteer? Well, that volunteering issue is a complicated one. When you are volunteering time for charitable affairs or religious matters, I don't think there is any problem. The moment it starts getting into the realm of commercial volunteering, it could potentially become an issue. Under the Fair Labor Standards Act, private companies cannot take free work, from what I understand. I'm not an expert in that area. So you have to be careful that the company is okay with it, and there are certain circumstances under which for-profit companies can accept volunteer help from unpaid people. Okay, so that's one issue. The second issue is, does it in any way interfere with your OPT? And the answer is usually not. If you got OPT while you're still in school, you may have to check with your DSO because schools have local rules. They are not necessarily USCIS rules. They have local policies which don't allow you to volunteer your time in commercial enterprises beyond a certain limit. So you can check with your school. Is active professional volunteering to a family member's company a violation? And I think I want to say no, but it really is something that I would not be able to answer in a blanket manner because there is no really clear answer. I personally think it is not a violation of your status if you're helping an uncle. But if it comes close to your own work, for example, you are talking about, can I let him use my license for his company? That could become problematic because if they are using your license, the implication is that you are working for that company. Now remember, under STEM OPT, you can work for multiple companies, but you've got to get approval from school for that. Okay. Can you be a partner in the company and also an employee of the company? And the answer is yes and yes. Again, under OPT as well as under H-1B. As long as you have a genuine employer-employee relationship, which means somebody can fire you. So if you own 90% of the stock or even 51% of the stock, who can fire you? That's something we worry about. Employer-employee relationship is required for both the STEM OPT, not for the first year OPT, but for the STEM OPT as well as for H-1B. Okay. Also, you can't do a green card for a company in which you own substantial stock. Yeah, I think those are the issues that I have seen in your case. Press star 5 if you have a follow-up question on this. Press star 5. Okay, there being none, let's go on to the next frequently asked question. Can two employers file H-1B for the same employee using an existing I-140? Let's take the permutation combinations. First example, you have two employers, A and B. Employer A got your I-140 approved. Can A and B both file for an H-1B extension beyond 6 years using the same I-140 approval? Yes. Keep in mind, if your I-140 stays approved for less than 180 days and employer A withdraws your I-140, you will not be able to extend H-1B beyond 6 years. But once it has been pending 180 days, any number of employers can file for an H-1B extension. Number 2 example, there are 3 companies now. Instead of A and B, they are now A, B, and C. A got your I-140 approval. Any company out of these can apply for an extension, and all of them can apply for an extension based upon an I-140 approved by company A. So let's see what other questions there are. I have a consulting company and a startup in PA. Both are interested to sponsor. They can both apply. Can anybody else continue my consular processing because you converted your green card to consular? The answer is no. You have to go through PERM I-140 again, and you will keep the priority date from the old case. Okay. *5 if you have a follow-up question. Press *5 if you have a follow-up question. Okay, this is from Georgia. Area code 678. Go ahead, please. Area code 678. Go ahead. You are unmuted, sir, or ma'am. Okay. I have put your hand down because it doesn't look like we are connecting. All right, let's see if there's any other frequently asked questions. There are none. So let's go back to the routine questions, the non-frequently asked questions. First one, LPR, which is a green card holder, needs to travel to India to care for family member. Can re-entry permit be extended? The answer is yes. Normally, if you look at their standard operating procedures, the USCIS says we will extend your re-entry permit in appropriate circumstances. But after, I think it is 2 extensions, we will only give you extensions for 1 year going forward. That's what their SOP says. But in my personal experience, they keep giving you 2 yearly extensions. Couple of things you need to keep in mind. When you ask for an extension, it should be fairly certain that you will come back within or by that time. If circumstances change and you're not able to, that's fine. And also remember, you can only extend your re-entry permit by coming back to the United States. You can't do it from outside the US. Okay? I hope that's clear. If you have a question, follow-up question on this, press *5. Okay, you had third question. In case USCIS take away my green card, yeah, you will have to start all over again. Okay, so this is from Virginia. Go ahead, Virginia. How can I help you?
Hey, Rajiv, thank you for answering my question. So the follow-up question I have, you said if the 2 years is over, should I be again come back and apply the next following 2 years to be I have to be in US?
What you will do is you will come back to the United States before the 2 years are over. You would then apply for an extension. Once the extension has been received by the USCIS, you can either stay for the biometrics, which will be scheduled in a few weeks, or you can go back to India. And actually, I prefer that you do your biometrics before you leave. So do your biometrics, leave, and you can have the re-entry permit sent to either the consulate closest to your home in India or to a friend or your lawyers in USA. Okay?
Okay, so second like 3 and 4 also I have to come here and do the same thing what I did first
every time you have to be in the United States.
Okay. So one more thing, Rajiv, quickly is I know this naturalization is 30 months, of course, 5 years. So if I already burned like around 20 months, when I re-enter and I want to stay back, will my 20 months will count again as naturalization?
That's a fairly lengthy question. I will give you the short of it, because the long form of it is fairly lengthy. For naturalization, you must have stayed in the United States physically for no less than half the time of 5 years, which is 2.5 years, 30 months. Number two, your stay outside the USA at one stretch should never be 1 year or more. Otherwise, your 5 years are reset and they give you 1 year off. So you have to wait 4 years and 1 day before you apply again. So your continuity does not remain. But look at Form N-470 if you are going to be working for a US company outside the United States. Okay. Good luck.
Thanks. Rajiv.
You are welcome, sir. Next question. Impact if pending EB-2 AOS refiling is approved on pending EB-3 downgrade with the same employer. So I think what you're saying is, if I have asked for an interfiling from EB-3 downgrade to EB-2 and that is granted, because if the AOS is approved, then you've got your green card. So obviously what you're asking is, what if my interfiling is approved and my 485 is now attached to my EB-2 application? If EB-2 AOS is approved, does USCIS close the EB-3 pending I-140? No, they do not. They will still adjudicate your I-140. Can denial of the downgrade have an impact on the EB-2? It could. What if they find out the employer doesn't have the ability to pay wages? That can be a problem for your EB-2 as well. Should I consider interfile of EB-3 to EB-2? I refiled prior to... Yeah, I think so. Yes, sir. That's what we are doing. Star 5. If you have a follow-up question, press star 5. The only time I would hesitate to do an interfiling is if there is a Child Status Protection Act issue, and then it becomes a problem. Okay. All right. Next question. Entrepreneur on H-1 and H-4 EAD, not on company payroll, and no profit sharing. Impact on getting EAD or green card. So I will answer this question in the abstract. I don't know the exact circumstances. If you own a company completely 100% as a passive investor, and as long as you are paying taxes for any kind of income you're receiving, and if you're not receiving any income, that's okay. You don't have to file taxes. But if it is indeed a passive investment and you're filing taxes or not receiving any income, I can't see what is the impact on your green card. But do discuss with your lawyers. It is an important element to share with them to make sure the forms that are filed for H-1 or green card are appropriate. Okay. Star 5 if you have a follow-up question. Star 5. Okay. Next question, number 6 is EB-2 to EB-3 downgrade. I-140 is pending. Interfiling receipt is not received. Can I send another interfile letter saying that already we sent the interfile forms, but we have not received any receipt? Can you? Yes. Is it advisable? I do not know. We've not come into this situation before. So I have not really, I don't have any particular advice for you. What you can do is you can have your lawyers contact the USCIS and ask them what they say. It might take them all day to get through, but it's worth asking them that question. Could it harm your case? I don't think so. You're not doing anything illegal. Could it delay it? I do not know. I don't think so again. But do I have definitive advice for you? I do not. Sorry. Star 5 if you have a follow-up question. Star 5. Yeah, I would check with the USCIS if I were you. Can I carry my minor son's passport and get it stamped while he remains in America? for an H-4. Again, this is a question you should send an email to the consulate and do share with me what they tell you. People do it, and it seems to work out also. But is it legal? I do not know the answer to that question. There is no law that I can see that prohibits it. I'm always reluctant to give, again, definitive advice unless I've seen the answer somewhere in writing. So might as well check with the US consulate. Okay? *5. If you have a follow-up question on this, press *5. Next question. Now this is a very weird situation. Kirti had his or her F1 stamped on the old passport. The passport gets lost and then he or she finds the passport. Now can they travel using the old passport? And I think the question will have to be answered by the Indian authorities. In my view, the appropriate thing for the consulate to do, and I don't know what they will do, is to you carry the passport to them, old passport. They cancel the passport. They usually put some kind of either they cut the corner off or they put some kind of like a punch through, a hole through the passport. But you should be able to still use that visa. So you'll carry 2 passports instead of 1. But do bring this issue to the notice of the Indian consulate. Okay. Should I avoid travel to India till I get an H-1B? I think you should definitely avoid travel until you've got this resolved with the Indian consulate. The issue is really you have a problem with 2 passports. And it's not really a problem of just the visa. So do check with the consulate. Let us see what they tell you. *5. If you have a follow-up question on this, press *5. There being none, let's go on to the next question. Applying for US citizenship after the green card, documents required. So terminated by employer A less than 180 days after 485 due to COVID layoffs. Joined employer B, which was approved in the same job, okay, which was approved in May 2020. I had not joined employer B when H-1 was approved. Okay. New employer didn't want to file 485J. I was eligible to file it. They wanted me to restart the perm. Okay. What nonsense. Got green card in September 2021. RFE for birth certificate, medicals. They didn't ask for 485J. Okay. Is there any precaution or documentation? The only thing I can think of is keeping some documentation that shows the sequence of events, what happened, and also that the 2 jobs were same or similar. If you have any emails from the law firm, the big law firm telling you to refile the green card, keep copies of that. But that's pretty much it. Your intent was to work for employer A. Yeah, I think so. I think you look like you're in a fairly safe situation. Can the government question this during naturalization? Yes. And you should definitely file for naturalization after 5 years and a few days of your green card approval. Okay. You do it before that, it's a lot easier for them to go after your green card. You do it after 5 years of your green card approval, it's much more difficult for them to go after your green card. *5, if you have a follow-up question. *5. Okay. This one is from New Jersey, I think. New Jersey, go ahead, please.
Yeah, so that was my question. Thanks, Rajiv, for answering. So from what I read on the H memo, it seemed to be okay moving before 180 days.
Right.
And then I got my green card. So,
Right.
Yeah, I'm just concerned if it can ever be an issue with.
They can raise the issue. Any damn fool can ask any question. Does that question mean anything? And I think legally, no, it does not. Okay.
Okay. All right. Thank you.
Good luck. Maryland has a question. Maryland, go ahead, please. 443 area code.
Yeah.
Go ahead.
Hello, Rajiv. Thanks for doing this
Of
service.
course.
It's like really helpful for people like us.
Absolutely.
I think I missed my question. This is related to
Then you
being a
I'm sorry.
company owner.
I'm sorry. You're going to have to wait till the recording is put out. I'm not going to repeat the answers, okay? So stand by. It should be
Okay.
posted within the next day or two. Okay, so then we come to, did I do that already? Yeah. Now the question number 12, is it possible to work for 2 jobs with 2 different approved valid H-1B petitions for a month? No. No. The only time you can work 2 H-1B jobs simultaneously is when you get an H-1B concurrent approval for the second job. It's just a different checkbox, but you can't work for 2 employers for the same period. You cannot. Okay, you can of course take a leave of absence. So if you wanted to test the waters between 2 employers, you can take a leave of absence from the first employer. You're not physically working there. I think that's a little better. I'm not sure that's completely legal, but at least it can be argued that you're not working and it's not simultaneously working. I think your chances of getting into trouble are a lot lesser than you out and out worked for 2 employers. *5. If you have a follow-up question, press *5. Area code 424. I don't know where that is from. Okay. Where are you calling from? Area code 424.
Hey, hi Rajiv, thanks for answering this question. We just have, let's say,
Hang on.
I'm sorry.
I asked you, where are you calling from?
I'm calling currently. I'm from Ohio.
Ohio. Okay, sir. Go ahead.
Sure. Then, thanks for answering the question again. So, thing is, you are saying I cannot work
No.
because these 2 are not filed concurrently. Let's say if I take an app, if I take a leave, and let's say, and then I work there, and then they pay me for that leave. I have paid leave. Is it a problem for me?
Well, look, this is an important distinction to remember. If you are getting paid for work you do, that could be illegal in these circumstances. But if you are getting paid for the work you have already done, for example, you have accrued unpaid leave of absence, I think that's okay. I'm sorry, accrued paid leave of absence is what I meant. If you have accrued paid leave of absence and you are taking that time, that's fine. I don't see any problem with that.
Okay.
All right.
Okay.
Good luck.
Sure. Thank you, sir.
You're welcome, sir. Okay, so working on green card EAD through spouse's pending green card filing with H-1B on hold with same employer. Yes, absolutely. So you can put your H-1B on hold when you start using your EAD. Just have your employer either revoke, or you can even, if you have an I-140 approval, you don't need to worry about preserving your H-1B time. But you can be working on EAD, you work on EAD. One day you decide, I want to get back onto H-1B. If you already have an H-1B approval, you just go outside the US, get a visa stamp and come back. You are back on H-1B. If you don't have an H-1B approval, get an H-1B approval, go outside, get a visa stamp and come back. So to trigger the H-1B back, you just need to travel out and back in. Come in on a visa, you are good. Any benefit to switching to another employer? I don't see, which my husband's green card may be rejected. You're sitting pretty, Shilpaji. I don't think there is a problem here because you can always convert to H-1B. I just explained the process to you. You can go to any consulate. You may not be able to get it from within USA. If you are on H-4 EAD, yes, you can. You can convert to H-1B within the United States. But if you are on, let's say, 485 EAD, you'll have to step out and come back in. Okay? *5. If you have a follow-up question on this, press *5. All right. This is from area code 813. 813, where are you calling from?
I'm calling from Florida.
Yes, ma'am. Go ahead, please.
Yeah. Thanks for answering that question. My question, my kind of another question is like, so if I am with the same employer, right, like whoever has my H-1B, is there any advantage of that, or it's the same even if I switch to another employer who doesn't have my H-1B?
It's no problem even if you change employers. Okay.
The process is the same. Like I have to go outside India, get it stamped, and come back.
Yes, but if you're on H-4 EAD, you don't have to go outside. You don't have to go outside. You can do it within the United States.
Okay.
See, you are on green card EAD.
Yeah.
Hang on. You are on green card EAD. So for green card EAD, you always have to step out and come back in. Okay.
Okay, but if I'm not working with the same employer, right? Like my H-1B, will it be like I'm saying the employer is someone in the H-1B, right? Like employer A, but maybe I'm currently working for employer B. So will I get it stamped without any issues? Like because
no
the
problem.
employer has changed now.
No problem. It's done all the time. Okay.
Okay, maybe I have to file an H-1B amendment.
Oh, that you do. You have to file an H-1B transfer if you're working for a different employer. So you'll file a transfer and an extension.
Do an H-1B?
Yes.
Oh, okay. And then go back and get it stamped.
Exactly. All right.
Oh, okay. Got it.
Good luck, ma'am.
Thank you so much.
Bye-bye. Okay. So now we come, this is an interesting question. I've answered this many times. So if there is an active I-130 petition from a parent, will the son have a problem getting an F1, F2 visa? And the answer is, well, that depends upon the consulate. It is their discretion. I've mentioned this many times. My nephew came to the US just a year ago on an F1 while his green card was pending. So it is actually up to the consulate. You can try. If you're a genuine case, they might be willing to give you an F1 visa. *5. If you have a follow-up question on this, press *5. Okay. The last posted question is from one of our community members. I'm being hired by a company in Ontario, Canada, locations in Michigan and Ohio. I'm also a Canadian PR, and I reside in Windsor. If they hired me on H-1B to be able to go to US 10 to 15 days a month and work from Windsor, are they required to pay me whatever LC approved salary is? They have to pay you from the US payroll for the days you are working here. The rest of the time you can be on Canadian payroll also. I don't see any problem with that. You can commute into USA for work. I don't see any issue with that. I actually have a client who's been doing it for over 15 years. He's an environmental engineer, and he's been doing it for 15 years now. Okay. *5. If you have a follow-up question, press *5. Okay, I think we are done with the posted questions. Anyone has any question, press *5. Okay. Anyone has any question, press *5. Ooh, we have 8 questions, 9 questions, 10 questions. Wow. Okay. Let's see how many we can get done. I want to begin in the order that you logged in. I wonder how I do that. Hold on one second. So the first person in that, I'll just do it manually, I guess. So the first person in that list is Texas. Texas, I have unmuted you. 972, area code 972. Go ahead.
Yeah, thank you for the call. I have a question like I'm planning to go for stamping in India. I'm working for end client, vendor, and employer layer. So I'm with my employer and I'm in H-1B. In that stamping, they mentioned end client letter from employer/petitioner. Could I know what is mean by end client letter? Is this mean like employer has to get a letter from the vendor, or do I need to get up from the end client, or how many I have to get a letter, or my employer?
Hang on. I have no idea what you're asking me, but I can tell you what is required generally. Okay. So what is required generally for an H-1B stamping is you must have a letter describing what you do and who controls you from the end client whose premises you work in. So if you work in the end client premises, you must get a letter from that end client. That's what they normally require. In addition, if there's a middle vendor, they also want to see a letter from the middle vendor. So they require both letters, but the end client letter is the most important. Does that help?
Yeah, so what are the minimum date details that need to be?
I can't tell you that. That's not something I can tell you. Your own lawyer should help you with that. There is a standard format, job description, duties, who controls you, etc., what degree is required. I can't tell you anything more than that. Let your lawyers help you with that. All right? Good luck.
Okay, and one more, if it is unable to get the end client letter, is there any other alternative document?
Yeah, you're looking at least a 15-20 minute discussion for which I do not have time. So there is alternative documentation possible, but it's very difficult to get that in. Typically, you require work orders that show all the details that I talked about. Normally, those are not there. You require master contract, any other contracts that exist between the various parties. So it's a lot more difficult to do that. Okay. So I gotta move on, sir. Good luck. All right. 1 second. How do I put the hand down? Oh boy. Yeah, guys, keep your questions brief, please, because we've got a lot of people waiting. So next question is from area code 903. Is that what I just answered? 903?
No.
Okay, go ahead, please.
I haven't asked the question yet.
Okay, go ahead, please.
Hello, Rajiv. This is from Texas.
Yes.
I wanted to ask a question about, I recently got my green card approved.
Okay.
My employer filed my adjustment of status in October 2020. In end of February 2022, I changed my employer, and the employer filed 485J to transfer the pending application. But within 4 days, I got my green card approved. So that's where my question is, that should I be going back to the employer through which I got the green card?
No. Your green card was approved more than 180 days after you filed the 485, right?
Correct.
Yeah, you're good. I don't see any problem. All right.
Okay. So the 485J is not yet receipted or adjudicated.
That doesn't matter. No, it doesn't matter. You filed it, you're protected. All right?
Okay.
Good luck.
Thank you, sir.
You're welcome. Coming to area code, this is New York. I'm going in the order in which you logged in, guys. So go ahead, New York. I can hear you. Area code 646.
Okay. Hey, yeah, so thank you, Rajiv. Question, I think everybody must be asking the same thing. With the recent visa bulletin, so date of filing moving ahead of final action date. If my final action date is not current, and I'm with the same employer who holds EB-3 and EB-2, a downgrade category, I got my EAD based on EB-3 downgrade. Can I interfile now, even though the date is not current?
I don't remember off the top of my head what the government instructions were, but I think your dates for filing have to be current, or is it final action dates that have to be current? I don't remember off the top of my head, sorry. You can email it to me, email me your question, I'll have it checked. Other people in the team keep track of all these details. So just send me an email to help@immigration.com. I'll have it confirmed for you. Okay?
Okay, appreciate it. Thank
Good
you
luck.
so much.
Anytime. Bye-bye. Okay, let me see if I can go on to the next question. All right, so this one is from Massachusetts. Area code 747. 747, go ahead, please. Area code, oh, I'm sorry, not 747, 781. My apologies. 781, Massachusetts.
Hi, Rajiv.
Hello, sir.
Hi, Rajiv. Am I audible?
Yes, sir, you are.
Am I audible?
You are.
Yeah, thank you for allowing me to ask this question. So, I just want to give my background first, asking the question. I am currently working for employer B. My priority date for green card is 3rd September 2013. I had a EB-2 140 with prior employer A. After that, 3 years back, I moved to employer B. Working for employer B, they applied a new perm in 2020, right when the big movement happened. So at that moment, they applied my perm, and last year in May or June, my perm got approved, and then I was in an option to either apply an EB-2 or EB-3. My company applied an EB-3 140 because that time the date was current. So they applied I-140, 485, 765, 131, along with the medicals, everything. And I got fingerprints done in November. I got an 485J RFP, even though my date is not current, asking to submit, a 485J, confirming the bona fide offer. So, and the question here is, my date is not current in EB-3, not in EB-3 and not in EB-2. But my 140 was approved in fiscal year 2021. And I've been reading on Trackit, like a lot of folks like this who are getting green cards where their date is not current. So what could happen? If I reply back, if I get the green card, my date is not current. There are a lot of folks that are like,
yeah, I think if I don't know the exact circumstances of these cases, but if the green card is being approved without the dates being current and the dates never were current, I think that is a mistake and that could be a problem. Okay, so
dates were current last year.
So
current last year in the year 2020.
I don't know what the government is doing. It's a good idea to check with the USCIS itself. I'll tell you how the system works, and I'm taking a little bit of extra time because it's an important issue. So the way it works is, in order for you to get a green card approval, two things have to exist. Actually, the most important thing is USCIS must have received a visa number for you. How do they get the visa number? Once they adjudicate your 485, they send an email or a fax to the Department of State saying, I need a visa number for this gentleman. Okay. Sometimes what happens is they get the visa number, but the dates then retrogress. That's not a problem because they already got the visa number. So are they using the visa numbers that are going to go wasted otherwise? I do not know what their SOP is. I have no information on this. That is the only exception I can think of, that they already have the visa numbers and they are using those. I don't know how that works. So the answer is it should be looked into, and if indeed it is a genuine approval, well, good, champagne is in order. And if it is not a genuine approval, government should put you back on 485 pending status. That's the best I can tell you. Okay.
How do we approach them? Like people are calling the.
I'm gonna have to move on.
They're not getting enough.
I'm gonna have to move on. You have a lawyer, get them working. They can go through the American Immigration Law Association. You can go through your congressman, and they can even call the USCIS directly. Good luck. Now on to the next question. Guys, be respectful. I've got 8 more people waiting. I'm not sure I can do all of them. North Carolina. Go ahead, North Carolina.
Hello. Hi, Rajiv. This is Ritu.
Hello, Ritu.
Currently I'm working for company A. and they have started my green card process. So they have applied for my PWD, and recently I received PWD, but in that I came to know that the wage came out 12,000 higher than my salary, what I'm earning now. So they have started the recruitment process with a higher rate. But now now my concern is, will that create any issue in the form or I-140 or the future H-1B extension with a lower rate?
Yeah, that's not a problem.
With a lower salary?
That's not a problem.
That's not.
Nope. Okay.
Okay.
Good luck.
Oh, okay. Yeah. Thanks.
You're welcome. All right. So let's go on to the next question. This one is from Georgia, I think 678. Okay, 678. Go ahead.
Hello, Rajiv. Thank you for taking my question.
Of course.
Can you hear me?
I can hear you. Yes, sir. Go ahead.
Okay. So, Rajiv, I used to work in US from 2006 to 2010. And my employer had filed I-140, which was approved with a priority date of July 2006. And after that, I moved back to India in 2010, and I've been working in India since then for a different employer.
Okay.
So I have 2 years of time period left on H-1B. So my question is, can I use that H-1B instead of going through the lottery system? And can I still keep the priority date if I don't use that H-1B?
Okay. So a couple of questions there. Do you know if that I-140 was revoked by the old employer?
I did not have the copy of I-140, so I used FI Freedom of Information Act to get it, and it still says approved in that document.
That doesn't matter. Have you been able to get in touch with your old employer? Are they still in business?
Yes, they are in business. I tried to reach them, but they said we destroyed all records after 7 years of losing the employment.
So only thing I can do is I can tell you my guess. You can try, because you seem to be falling under the law that existed or the regulations that existed prior to January 17th, 2017. Under those regulations, prior to 2017, things were quite murky. We don't know how a lot of things worked. It's highly doubtful whether you can keep your priority date if your petition was revoked. But it was not revoked, you should be able to keep your priority date. And if it was not revoked, you should also be able to get an H-1B extension based upon that I-140. These are a lot of ifs and buts, but that's where we are right now. So what should you do practically? Try to get an H-1B extension.
We will know if it was revoked by asking the employer?
Yeah, that's the only thing you can do, the lawyers or the employer. Okay.
Okay, only they can tell me whether it was revoked or not.
That's right. That's right. Okay. Good luck.
Okay, thank you so much.
You're welcome. Okay, so let's see how many more we can do. We have, let's see, this is from Connecticut. Connecticut, go ahead please. Connecticut 860.
Hey, hi. Thanks for taking this question. I recently got my green card in EB-3.
Right.
However, in the category, they listed E31 because I was hoping it will be E36. But when I'm looking into category, they listed as E31. So is there anything I need to worry or?
I don't know the category designation off the top of my head. But if the category is wrong, you can, again, the best thing is cases like this, just contact your congressman's office, have them find out for you what's going on. Better to ask now than to be have a problem later on. So go ahead and ask them now. Okay.
Okay, because both are same, like, all are both E31 and E36 are for skilled workers for EB-3 category. But one says new arrivals and the other one 36 says adjustment of status. So
So you are 36 and that should be the category. It doesn't look like a major issue to me, but if you have a doubt, why not just contact your congressman's office, have them sort it out. Okay? Good luck.
Thank you.
You're welcome. Okay, so we have 4 more questions. Let's see if we can do them all. Let's go to California. California, I can hear you. Go ahead, please. Area code 408. California. All right.
Rajiv, sorry, yeah. So
Yeah.
thanks for taking the call.
Right.
Probably this topic might have been discussed already. My priority date is August 2011, and my 485 is stuck at Nebraska since October 2020. And there are no updates after my biometric in May 2021.
Right.
So the question is what's your take on interfiling while I'm current in both EB-2 and
Yeah, I would do the EB-2 interfiling if that's available. Okay.
Okay, so any success you came across with the recent interfilers to California already?
I don't know what that means, but I can tell you what I would do. I have nothing else to tell you. Okay. Good luck.
Okay, so you recommend
I certainly recommend it, sir. Yes. Let's go on to the next question. Yeah, I think EB-2s are more likely to go through hopefully by September. That's what the government has said. So let's go to Utah 801. Okay. Utah, go ahead, please.
Hi, Rajiv. I'm calling from Texas. I had a question. Is an EAD AP card tied to a particular AOS, or does it cover all the 485s?
Well, if you have
specifically,
if you have that's a difficult question to answer. If you have 2 485s alive and you have 1 EAD AP, it's good for you. Okay. So, but if the 485 on which the EAD AP is granted is revoked, or denied, I think you lose everything. But you've got the other 485, though you don't have advanced parole or employment authorization. So I can't answer that question in the hypothetical, but it is tied to that particular 485, but it doesn't hurt another 485. Let's put it like that. Okay?
Okay. All right.
Good luck.
Thank you.
You're welcome. Okay. Second last question. This one is from Virginia, area code 571. 571. Go ahead, please. 571.
Hey, Mr. Rajiv, thanks for having my question.
Of course.
Can you hear me?
I can hear you.
Okay. Thank you. My sister, who is a British citizen, she came to the United States a few years ago, pre-COVID, on the ESTA visa, where she is British. So while she was here, she had to extend her visa. She was extended, approved. But the clerk, the office USCIS person did not update the system back then. And now when she's applying for visa now, she's getting rejected. They think she overstayed it last time. But she has all the proofs and all the communication that her visa was granted and she got it was approved. What like you guys saying they can't do now anything because it's been like several years ago. So my question is what she can do, and if we need to get at your service, how much it would be?
No, hang on. I don't see what I can do. There are 2 things she can do which she must try first. First thing she should do is she should go to the airport in London and see if she can talk with the Customs and Border Protection. I know that they have in London, as well as they have a full-fledged CBP office in Ireland. So you can check with them and see if this can be corrected, because ESTA is really a CBP issue the way I see it. It's not a consulate issue. Number 1. Number 2, what she can do is she can open and Google this CBP Travel Redress Inquiry Program. So she can do a trip report and just put a trip case that my case has been mishandled I should be allowed entry on ESTA. So try talking to a CBP officer first. If that doesn't work, do a trip filing, and that can be done online. And the third thing is to just go get a tourist visa from the consulate. Okay? Those are the three options.
Sorry, what was the last thing?
Just go get a tourist visa from the consulate.
Oh, tourist visa.
Yep.
Okay, thank you so
All
much,
right.
sir.
You're welcome. All right, we are heading into the last question. And that question is from New Jersey. Okay. Area code 201. Go ahead, please.
Yeah, thank you for the call. Actually, my scenario is like my wife, she was working for the employer A, and she filed, the employer A filed the I-140 with priority date 2014 in EB-2, and the next month, mostly she will be getting that final action date. But she was in India, and she got H-1B rejection the last time. So she was working for another employer, employer B.
Mm-hmm.
So while working for employer B and in India, can employer A file the I-485 next month for her?
Is she in the United States right now?
No, she is in India.
You can never file a 485 for somebody who is outside US.
So what are the other options they can file the green card?
What is your current status? Are you in USA?
Yeah, I'm in USA.
What is your status?
I'm in H-1B.
Bring her into the United States on H-4, then she can file adjustment of status. Okay?
The situation is she cannot come because of some medical things and all.
Then she can't do a 485. She can't do a 485. But if the job with the employer A is still available, they can convert her green card to consular processing. Talk to your lawyers. I can only give you hints here. I'm not going to describe the whole process. Talk to your lawyers. They can convert the process to consular processing. That way, she can get green card interview in India. All right?
Oh, great. That case, there is an option.
Yes.
They can apply next month itself.
Yes. Yeah, well, it's not going to be that quick. No, it takes a long time. But that's the only option you got. Okay? If she can't come into the US, I think what she should do personally, and I have only about a minute left before I have to go. What she can do is she can come into the United States on H-4, even if she comes for a week, 2 weeks. Let her apply for her 485, your 485, then she can go back to India. Okay? Because she has an H-4. So
she can come, she can come in a tourist visa also?
No,
instead of H-4?
Absolutely not.
No.
Nope.
Oh. And just to know,
sir,
she got a H-1B rejection.
You have two choices, sir. You have two choices. Talk to your wife's lawyers or set up a consultation with us. This is all the time I have right now. Okay? Good luck.
No, thanks a lot.
You're welcome. Folks, my time is limited, so normally we focus on the posted questions. Post your questions ahead of time. I will answer every one of them. But other people I have a lot of hands still raised. I can't do anything about that, sorry. I got to finish this call. So I'll see you again in 2 weeks. Good luck, folks. Bye-bye.